Hi everyone, my name is Mark Veloso, contributor with Litigation Help, and welcome to our video series entitled Case Law Minutes, where we'll highlight the most frequently cited family law cases listed on the Ontario Superior Court website. Our video today is on Stone and Stone, decided in 2001 by the Ontario Court of Appeal. This is a family law case that concerns the equalization of net family property following the death of a spouse, particularly whether surviving spouse has any legal recourse in the event their deceased spouse disposes of his assets to a third party in order to deny the other's entitlement to equalization of property. Please remember that this video presentation is for general legal information only. For advice on your specific case, please consult a lawyer. In Stone v. Stone, the husband and wife were married for 25 years before he passed away. Each had children from their previous marriages, but the husband did not want any of his assets to go to his wife's children. After being diagnosed with cancer, the husband made inter-vivos transfers of all his business assets to the two adult children from his previous marriage. The word inter-vivos, which comes from the Latin phrase meaning between the living, is a legal term that typically refers to a transfer or gift made by one party to another during one's lifetime. This is in contrast to a testamentary transfer that takes effect on the death of the giver. Upon her husband's death, the wife elected under Section 6 of the Family Law Act not to take her legacy under the deceased's will, but instead to take her entitlement through an equalization of the net family property. Section 6 of the Family Law Act allows a spouse to receive their entitlement to a share of the deceased's estate through an equalization process of the couple's net family property, rather than what they were bequeathed under the will. The process for equalization is set out in Section 5(1) of the Family Law Act. It states that when a divorce is granted, or a marriage is declared a nullity, or when spouses are separated and there is no reasonable prospect that they will resume cohabitation. This also includes the death of a spouse, of course. The spouse whose net family property is the lesser of the two net family properties is entitled to one-half the difference between them. What complicated matters in the case at hand was that due to the inter-vivos transfers of the deceased husband's assets, there was virtually nothing left in the estate for the wife to claim through equalization under Section 5(1). The wife sought to have the transfers voided by the court and returned to the deceased's estate under Section 2 of the Fraudulent Conveyances Act. The purpose of this was to bring effect to the equalization process under Section 5(1) of the Family Law Act, which would otherwise have been frustrated by her husband's preemptive transfer of assets. Section 2 of the Fraudulent Conveyances Act allows a court to void any and all conveyances of property intended to hinder, defeat, delay, or defraud creditors or others of their just and lawful claims. The two primary issues before the court were as follows. First, does the Fraudulent Conveyances Act apply in the context of the Family Law Act? Second, was the wife a creditor or other which would provide her with the status to challenge the transfers under the Fraudulent Conveyances Act? We'll deal with the applicability of the Fraudulent Conveyances Act first. The two adult children of her husband argued at trial that the Family Law Act was a self-contained code intended to regulate financial relations between spouses, and that there was no room for the Fraudulent Conveyances Act to operate on the rights of the spouses in respect of each other's property. The court, however, rejected this argument. Drawing on an analogy with the use of constructive trusts in a family law context, the court made clear that the Family Law Act does not constitute an exclusive code for determining the ownership of matrimonial property. The quote I've chosen to highlight here comes from paragraph 44 of the case. In paragraph 44, the court states that there is nothing in the Family Law Act which outs the operation of the Fraudulent Conveyances Act as part of the process to determine the net family property of each spouse as of the applicable valuation date. Having decided that the Family Law Act does not preclude the application of the Fraudulent Conveyances Act, the courts next turn to the issue of whether, for the purposes of Section 2 of the Act, the wife qualified as a creditor or other. In paragraph 25 of its decision, the court emphasized that in order for a spouse to qualify as a person who is intended to be protected from conveyances of property made with the intent to defeat her interest, she must have had an existing claim against her husband at the time of the impugned conveyances, that is, a right which she could have asserted in an action. In deciding to void the husband's inter-vivos transfers to his adult children, the court reasoned in paragraph 32 that the deceased's transfers of property were made with the intent to defeat the wife's entitlement to equalization. Thus, because she had the right to apply for equalization at the time of the transfers, but was deprived of her ability to exercise that right, she was a creditor or other within the meaning of the Fraudulent Conveyances Act, and was entitled to its protection. The legal rule, or ratio decidendi, that emerges from the court's decision in Stone v. Stone are as follows. First, a spouse qualifies as a creditor or other for the purposes of the Fraudulent Conveyances Act if she has an existing claim against the spouse at the time of the impugned conveyance, which she would have asserted in the action. Secondly, the Family Law Act does not oust the operation of the Fraudulent Conveyances Act as part of the process to determine net family property of each spouse as of the valuation date in appropriate circumstances. To learn more about the court's reasoning in this decision, you may access the full case on the CanLII website link provided above. Thank you for watching, and I hope you enjoyed this installment in our series Case Law Minutes.